Okay, welcome back everybody to House Energy and Digital Infrastructure. It's Friday, January 9th, and we are here for testimony on the definition of single plant in statute. That was an issue we worked on quite a bit last year and took a lot of testimony and asked the PUC to do some work and report back. So we're going to start out with Ledge Council, who's just going to remind us of what we accomplished last year. I'm Representative Kathleen James. I'm from Manchester.
Scott Campbell from St. John's Ferry.
Richard Bailey, Lamoille 2.
Chris Morrow, Windsor, Bennington.
Christopher Howland, Rutland 4.
Vera Torrey, Washington 2.
Graham Sutton, 13, Burlington.
Laura
All right.
Civilian, Wyndham 50.
Great. And online.
Michael Southworth, Caledonia 2.
Great. Thanks, Representative Southworth. And here in the room, we have.
Peter Sterling, Renewable Energy Vermont. So excited to be back.
Good. Great.
Steph Hoffman, General Counsel for the Public Utility Commission.
Super.
And Wes Skidmore, Staff Attorney with the Public Utility Commission.
Great.
Tennessee Lamb with the Nebraska.
Super. All right. We're going to turn it over first to our Legislative Council.
Helen Tchaikovsky, Office of Legislative Counsel. So last year you passed out of the committee S38. Yes.
S50.
S50, which became Act 38. And that bill had to do with 25 is the new 15, changing the threshold related to net metering. But at the end of the session, you started looking at this issue regarding the definition of plant.
That's right.
It's not the definition of single plant, but the issues arise when there are more than one plant and the distinction between what is a single plant and what are multiple plants. And the reason that is an issue is that it's a defined term in Title 30, Chapter 89, which is the Renewable Energy Program chapter. And it is used more than 200 times in that chapter. And it is the definition that is used. It's sort of the basic unit of an energy system is what is a plant. So it's used frequently, but it is also part of how the PUC distinguishes or makes decisions about what things qualify for certain programs. So you will hear about that more from them in a moment, but I'm going to read you what you put into Act 38. So the issue came up, you had some time for testimony at the end of session, but it was May, and the things that are at issue with this definition are fairly technical. So you asked the Public Utility Commission to work with stakeholders and look at the issues regarding this definition. So in Act 38, you added this language in Section 5. It's posted under my name today. I can't remember if I already told you that, but here it is. On or before November 1st, 2025, and with input from stakeholders, the Public Utility Commission shall submit a recommended amended definition of plant in 30 VSA 8002-18. 8002 is the definition section for Chapter 89, and an overview of their process and explanation of the recommendation to the House Committee on Energy and Digital Infrastructure and the Senate Committee on Natural Resources and Energy. In making its recommendation, the Commission shall consider the land use benefits of co-location of energy generation facilities, the ability to ensure comprehensive review of co-located facilities, and the potential impacts to ratepayers associated with co-located facilities.
Great. Thank you for that reminder. I just want to bring us back to basics. So that is what we passed. That is what we asked the PUC to do. Thank you.
You're welcome.
And I think we can now bring on our next witnesses to. Oh no, I'm going to stay. I'll be here. Switch seats.
So much. Good afternoon. Thank you, Chair James and committee members for allowing us the opportunity to testify today. My name is Steph Hoffman. I'm General Counsel at the Public Utility Commission. With me today is my colleague, Wes Skidmore. And we're here to walk you through two different filings we made related to one another. one directly in response to the act that Ellen just went through with you, Act 38 of 2025, and the other companion memorandum that we submitted, a letter explaining a decommissioning proposal that we think goes hand in hand, because the same interested parties and participants who come before us to seek certificates of public good are affected directly by both of these projects that we grouped together and are proceeding to invite them to talk about these issues during the last year. So before you is a copy of this presentation, and I'm going to be going through the first half of that that deals directly with what Act 38 of 2025 asked of us. And then my colleague Wes is going to talk to you about the decommissioning proposal that we brought together with that proceeding. So as Ellen already discussed, we needed to provide a recommended amended definition of plant from 8002. That definition does affect principally siting of generation projects, the vast majority of which are solar projects.
I'm sorry. Did you want to share your screen or no? Should we just all go through the handouts?
I didn't bring a computer.
Okay, great. Sorry about that.
Talking with people. Sometimes I have it on a flash drive if you prefer to have it up on the screen.
Nope, we have it. I didn't mean to interrupt. Go ahead.
No, absolutely. Please. I want everyone to have access to the information. So stop me at any time. This definition principally functions for three different types of renewable energy programs that the Commission has to look at when citing facilities. Those are the net metering program, the standard offer program, and compliance with the renewable energy standard. It functions much differently in those three categories. The first two being financial incentive programs, meaning you're going to get paid as a developer of a net metering facility or standard offer facility a certain amount of money to generate that power. And those programs have capacity caps. The standard offer program is capped at 2.2 megawatts. The net metering program capacity cap is 500 kW, kilowatts generated by the facility. And those caps are tied to the fact that there's a ratepayer impact for those costs of producing power. In the renewable energy standard category for renewable energy programs, that's to determine whether compliance for utility purposes, whether the utility is going to be able to use that project for tier 2 and tier 3, et cetera, is they're eligible or not for that program. So we engaged with a number of participants in our process and considered the three statutory directives that you saw in front of you here, which were land use benefits, comprehensive review of these facilities when they come before the Commission, and ratepayer investments. So for a moment, I'm going to explain why in this context we linked these two subjects, both the definition of plant and decommissioning, so you understand why Wes is going to talk about decommissioning in a few minutes. We opened a proceeding right before this legislation became effective on June 30th of 2025 in order to invite the relevant participants to come to the Commission and provide us with information, share information, and engage in a dialogue about the definition of plant and decommissioning. We sought any and all definitions, proposed definitions of the word plant and statute as part of that initial order opening the proceeding. So basically seeking the gamut of what people were looking at and thinking about. And we also put out affirmatively the statutory language we shared with you on decommissioning and what our proposal was for decommissioning. We wanted to start that conversation from a very stable starting point because it was something we were initiating with this group of interested people. We ended up receiving and soliciting 2 rounds of written comments, and we held 2 workshops, one on the definition of plant and one on the decommissioning proposal. At the end of that process, this sort of bilateral process of receiving feedback and giving out information, we put out a proposed definition of plant and asked for one more round of feedback on that definition before concluding and writing the report that we submitted to your committee. The Commission has been thinking about the issue of decommissioning, just to give a little bit more background on why that got linked here, how we do decommissioning, how we ensure decommissioning happens of these facilities at the end of their useful life. We've been thinking about that question for years. In 2017, we actually promulgated a rule in response to the language in section 248B5, A5, which requires the Commission ensure that decommissioning occurs when facilities are built on sites, meaning if that facility goes out of use, how is it going to be taken down? How is the site going to be restored? We're charged, the commission is charged with ensuring that decommissioning occurs. Sorry, go ahead.
Just a quick question. Are we just talking about solar projects or any kind of energy generation facility?
That provision in statute applies to any type of facility. Wind, solar,
Would
hydroelectric,
hydro,
Nuclear.
nuclear has its own set of specific provisions regarding decommissioning that are separately set out in statute. So that A5 provision is not enforced on their facilities. What we've done historically before our rulemaking in 2017 and after it is we've established a set of conditions in any certificate of public good that require decommissioning, a decommissioning financial instrument be filed with us. So when a facility is proposed, it receives a CPG, they go to mostly banks, sometimes insurance companies, they receive traditionally a letter of credit. And they file that original instrument with the commission, securing the decommissioning. That letter of credit is held in the amount of a decommissioning fund estimate for when that facility is going to be decommissioned. And we're talking about decades in the future, right? Solar facilities useful life may be anywhere between 20 and 40 years, just as an example, assuming it's going to come down at the end of that time rather than, let's say, repurposed or repaneled. That process has many complexities because they have to continually refile these financial instruments with us over the course of the life of the project. And the cadence that they're required to file those under our current rule is every 3 years. Some facilities have an obligation to annually file with us. So on an annual or at most triennial basis, facilities have to seek out new instruments. The CPG holders seek out new instruments, they file them with us. We determined that this process, after we'd received feedback from several CPG holders, and we had actually recently gone through a comprehensive audit of everyone who has compliance obligations with the commission, and to see how many of those facilities are in compliance and what they needed to do to come into compliance, we determined that there must be something going on with decommissioning that's causing some impediments to that compliance. And also we'd heard some feedback that these products are difficult to obtain. So we ended up saying to ourselves, okay, what are some other alternative methods of looking at this problem, and to start conversations around that? Because all the same folks were going to be in the room, we paired that with the definition of plant and asked these questions because we had representatives of developers and CPG holders in that proceeding, folks who represent interest groups about renewable energy and other types of folks that appear before us, plus the state agencies that are charged with reviewing these facilities, all participating. So we brought both of these topics together, and that's why we presented them to you at the same time. Now, in our report on the recommended definition of plant, we have proposed, after much engagement with these participants, a definition that does several things. First, it sets a new kind of general standard. And that standard is essentially that a plant is a single plant, it's one plant, if it has if it's on the same or contiguous parcels of land, and if it uses the same generation technology, solar, wind, hydroelectric, etc. So that's the standard. So if you are on the same parcel and you are a solar facility, you are one plant. But there are exceptions to that. And the exceptions are each policy-driven exceptions that are also looking at the 3 factors the legislature asked us to consider. The first exception is what is A in the definition, individual residential net metering. Nothing about this definition should prohibit one homeowner who lives next to another homeowner from each having a roof-mounted solar facility at their house, let's say. If we use the definition same or contiguous parcels, we'd end up prohibiting neighbors who come second to that from building a solar facility, a small residential solar at their house. So that's what A is attempting to exclude from the definition. We don't want to prohibit neighbors from developing solar. B is multi-owner individual residential net metering. Essentially, if you have housing development, duplex, triplex, quadplex, or even some scenarios with buildings of homeowners who each have their own billing meter for electricity, we don't want to prevent them also from taking advantage of residential solar. We see development where you might have a duplex where the developer wants to put solar, it's part of the package, maybe this is a renewable home, etc. You don't want to prohibit it such that only one solar installation can be on that parcel of land at that duplex, because you end up then with a situation where only one homeowner, only one billing account could be associated. So you're basically cutting out one of those duplex eventual owners from having solar at their house.
I'm sorry, just to clarify, you probably said this, but it went by me. So this is the threshold that is the meter. Is that right? So a separate meter can have, each meter can be associated with a renewal.
Yes, the billing meter is used as the separation.
Okay.
Yes. And then the third exception here is more than one renewable energy program facility, so long as there are different points of interconnection. And what that definition is, and it's not part of the net metering or standard offer program. What that portion of the exceptions is meant to deal with is, we want for res compliance there to be the opportunity for multiple facilities to be on the same parcel or contiguous parcels, so long as they're interconnected separately. Because the res compliance portion of the definition of the program for res is not meant to use plant to say, oh, we need to make sure that these are not receiving a financial incentive. That's not what res is doing. Whereas net metering and standard offer program are providing a financial benefit to someone who's developing, and there are capacity caps associated with that development to try to limit what incentive is available, that there's ratepayer impacts for that. And therefore also concerns that they basically would be able to violate those program caps if they are allowed to develop more than one facility in a co-located way. Whereas the res, it's not targeted toward that type of a purpose. So that's what that definition exception is meant to do. And then the final portion of the definition is a set of definitions meant to clarify terms that we use in our proposal. Any questions or concerns about the actual wording of the proposal?
I'm sure there are. You went very fast and very, great. It's just. And do we have the proposal? Yeah. So.
Yeah.
So now.
Yes.
Yes.
Oh, yeah.
Would it be fair to say that the term single plant then is a subset definition of plant?
We just use the term as a full term of our single plant when we're referring to a determination that it is in fact one facility, one plant. It is, the word plant is itself a single plant. And if you meet this definition, you are one plant. If you are more than one plant, then you would be outside of the definition. So basically you are one plant, you are a single plant. If you use the same generation technology and you're on a single parcel, then you're contiguous parcels of land. Otherwise, you are multiple plants.
So if a standard offer plant exceeded the 2.2, it would become two plants on a single parcel.
If you're putting, let's say, a solar facility on the same parcel of land, no matter how big it is, it cannot be in the standard offer program if it's about 2.2 megawatts. That's what we're looking at when we determine eligibility for the standard offer program.
And so I thought the single plant limitations was one connection to the electric grid not to exceed 2.2.
Well, the current definition of plant actually uses a number of factors to determine whether or not a facility is a plant. And that the way the statute is currently written, it asks us to ask whether it's the same project, defined as by three terms, contiguity and time of construction, same owners, and proximity. And then does it share infrastructure or equipment? And so, yes, a point of interconnection would be a form of infrastructure or equipment you could share, but the Supreme Court has looked at a number of things like sharing distribution lines or distribution line upgrades or sharing transformers. There's all sorts of infrastructure and equipment that could be shared. So right now, the definition asks us to do this very onerous and expensive look at each facility, how it's constructed, the entire history of the facility's planning, to determine whether or not it is one facility. And our attempt here is to make that process a lot simpler and a lot more efficient. We look at these two factors that are very yes or no type factors. If you meet them, you are a single facility or a single plant. And if you don't, then you're separate and you can be treated as two standard offer, two net metering, et cetera.
Did you have a question or comment?
Yeah.
For the record?
Ellen Tech, the opposite legislative council. Can you talk more about the third exception? I'm slightly confused about how it is used. Because you refer to standard offer and net metering and tier 2. And so I am trying to pick, can you talk just a little bit more about how that works? I'm a little confused on that one.
Yeah, absolutely. You can't have more than 500 kW in a net metering program on the same parcel or contiguous parcels, or 2.2 megawatts of solar for the standard offer program on the same parcel or contiguous parcels under this definition. Otherwise, you violate those programs and therefore you're not in that exception.
Mhm.
If you're not participating in the net metering program or the standard offer program, but your solar is being used for a PPA contract with the utility to satisfy the res, all we look at is points of interconnection.
Okay.
That's what C is doing.
Okay.
And if I'm, Mike, just to clarify, I think that same point. So if someone had a 500 kilowatt offsite community net metering facility, and there happened to be adjacent to it an excellent spot for another couple of megs that they just wanted to do as a PPA, they had a separate interconnection, that wouldn't screw up the original 500 kilowatts.
It would not under this definition. Under the status quo, it would have you would aggregate all of it to look at.
Right, but under the new definition, it would not screw it.
You can max out up to the program participation, but beyond that, as long as it's outside of the programs, we're not concerned with anything but point of interconnections.
Got it. Thank you. That makes me happy. Not that that's the goal of legislation necessarily.
Okay.
All right. I'm going to turn it over to Wes. Thank you so much.
Thank you.
Thanks, Steph. Thanks, Chair James and the committee. Steph did a great job of sort of introducing my half of this testimony, which is on the decommissioning topic. Just to sort of hone in at what we're talking about the financial obligation that a non-utility generating facility has to restore a site at the end of its useful life, which encompasses removal of the generating technology apparatus and restoring the site to its original condition. That is a obligation that the PUC is tasked with ensuring under Section 248A of Title 30. And currently, our process for ensuring that is by requiring developers to take a series of steps when they apply for a CPG with us. Those steps include obtaining a decommissioning cost estimate, providing the same with us, providing a draft financial instrument, usually from a bank, that articulates that cost estimate and contains an obligation that the bank or financial institution will make good on that estimate at the end of the useful life of the facility if the developer is not able to decommission on their own. So what we're really aiming at is restoring sites to their original condition after the generating resource is no longer useful. So currently, the financial institutions have to be A-rated. Those instruments have to be filed with the commission and updated somewhat frequently, typically every 3 years to adjust for inflation. Then at the end of the useful life of a facility, the developer does have an obligation to decommission. And in the event that the developer did not meet that obligation, the commission would call on that financial instrument, often a letter of credit, as Steph noted, for the full amount of the decommissioning obligation. And that's sort of where things grind to a halt from our standpoint right now. And I'll explain what I mean by that. But just first to define a couple terms. So decommissioning is the process by which a CPG holder or other responsible entity removes a generation or storage facility at the end of its useful life. Financial assurance is the umbrella term that I'm going to use to describe various assurances provided by CPG holders to ensure that the money needed to decommission is there when it needs to be called on. Financial surety instrument, like Steph noted, could refer to a letter of credit. It could be a surety bond, or it could be an escrow agreement between a developer and a third-party financial institution like a bank or insurance company. And typically we see letters of credit or surety bonds. And those are the legal documents that actually guarantee that financial obligation. So currently, commission staff are required to triennially engage in tasks, really compliance-related tasks related to these decommissioning obligations. And developers are as well. Inflation adjustments, updated financial instruments. These are all things that are filed into cases with the PUC as part of developers maintaining their compliance obligations that were part of their CPG. The problem I mentioned earlier, I've broken it in on the slide. I sort of broken it into 3 separate problems, but I think there also is a fundamental problem, which is we're tasked with ensuring decommissioning at the end of the useful life of facilities, but we do not otherwise regulate the people performing that work or the tasks related to successfully decommissioning a facility. So we do not regulate merchant generators, so independent developer of an energy resource, in the same way we do utility companies. Essentially, and Steph, you can correct me if I'm wrong about this, but our interaction with developers is largely limited to the CPG process. So once a CPG is obtained for a facility, our interaction with those developers is limited to those ongoing compliance filings for the most part, unless, of course, they were to try to construct another generation facility. And the last point here is that the Commission does not currently have statutory authorization to meet our decommissioning obligation, which in statute is to ensure decommissioning in the event that a developer was non-compliant at the end of the useful life of a facility. So we have financial instruments. These are paper copies that we have in our offices that are theoretically our ability to make good on a developer's decommissioning obligation. But we don't have any statutory authorization from that point onward. So if we needed to actually use that document and go to a bank and ask for the, let's say, $200,000 of inflation adjusted funds, we don't have an account to place that money into. And there's no clearly articulated process for us to follow. And it hasn't come up yet, largely because a lot of these facilities are relatively new in the last 10 or 15 years. But it's something that could be on the horizon in the next decade or two. So if we were to try to call on a financial assurance, so a letter of credit or a surety bond right now, we have nowhere to deposit them, as I noted. We have no statutory authority to place these funds into any particular account to make use of them. Obviously, maybe this goes without saying, we and the folks in our office are not skilled at the actual work of deconstructing a generation site. So we have little to no guidance about what would go into that and retaining contractors and what that process would look like. And the other important thing to note is enforcement of one of these financial instruments could be quite complex because we're not going to a developer 20 years from now to seek enforcement. We're going to a bank. Oftentimes, we typically require an A-rated bank. Those are often very large banks. And so actually calling on that instrument to ensure that we meet our obligation to decommission this, to ensure that the site is decommissioned, could be legally and administratively very complex. On top of this, and Steph noted this earlier, the current system related to decommissioning relies on regular developer compliance with various filing tasks that are placed on them. this is typically the inflation adjustment. That's primarily what I'm referring to. Every 3 years, most decommissioning instruments have to be adjusted for inflation. But there are other related filings that do have to be made on a 3-year basis. The commission recently engaged in a general compliance audit, and we found that between 60 and 65% of facilities that were required to maintain financial instruments for decommissioning were out of compliance. We think this demonstrates constraints on the part of regulated entities, merchant generators, and it's difficult for us to manage that system because it inevitably involves us chasing new paper documents from developers that already have their CPGs. The last point is there's a lot of uncertainty and liability, both for our agency and for the state, related to the status quo. The crux of this point is really that financial assurances are meant to be used when a CPG holder has defaulted on their obligations at the end of the useful life of a facility. Typically, that could mean that a CPG holder is unable to be located, it has become insolvent, or you could imagine things of that nature. And that makes it very difficult for us to engage with them in a regulatory capacity from that point. So there's inherent risk with requiring this consistent engagement between developer and regulator. If an instrument is not maintained throughout the life of a facility, there really is no financial assurance in place to allow us to ensure decommissioning. And then a last point is just we're also depending on solvency of the financial institutions. So what we're proposing is a fund model. And I have this slide where I detail some of the attributes that we're suggesting that model would hold. And those are, it's an upfront contribution idea, paid into a fund. The fund would be managed by, we think the best approach would be a combination of the commission and the treasurer's office. We think the fund could grow over time following some sort of market mechanism. The federal bond rate, for example, would be one option. That fund would be available and would be held regardless of delinquency on the part of developers. So if a developer is insolvent 30 years down the line, the fund is still there and is still controlled by the state. The fund would, we think, be best suited to cover commission costs for administration and to account for overruns. And we coupled the single plant definition recommendation with this recommendation about a decommissioning fund being created, primarily because of overlap between the parties, as Steph noted. So the process for this was pretty much followed the single plant process. We opened an investigation on June 25th of last year. In July, we received a first round of comments on the decommissioning proposal. We issued a draft conceptual plan for the decommissioning fund proposal in September. And then we held a workshop in September seeking feedback from participants and interested parties. We received multiple rounds of comments, answered various questions and concerns on the proposal. Most of the feedback, if not all the feedback, was centered around how to calculate amounts that would be contributed to the fund, which is a natural question a developer would have. And the important point here is the statutory language we've proposed in the letter we sent to the committee would authorize the creation of a fund, and that would be followed by a thorough procedural series of steps at the commission level to arrive at those kind of answers, to receive input from interested parties and professionals and experts on what that fund would look like, what the contribution percentages might look like, what numbers would be reasonable or unreasonable. And so our proposal currently is really limited to getting the fund created, and all the details would be arrived at through rulemaking and other commission procedures after the fact, because we need the input of experts.
I think we have a question, Rick Sebelia?
I'm just wondering, still reading through the comments here. Thank you for including those. If this decommissioning fund, I'm familiar with sort of decommissioning fund for Vermont Unity. And those funds are available to and belong to the company that owns the site. Who would own these funds? And the interest, and did the commission contemplate that?
There's two ways to construct, I think, this fund. The two cleanest ways are you're either forfeiting the funds to the state as a contribution up front that is held by the state, in trust for this purpose. And the model we proposed gives us also the flexibility to return the funds at the end of a project's life if the decommissioning is performed by the CPG holder and the site is reclaimed as it should have been according to the CPG. Both of those models follow models that ANR uses for holding a site cleanup fund. There are models there where you're making an upfront contribution should there be an issue on a site as sort of a participant in that field. And then there are brownfield type models where there's a return on investment when the contribution is made at the beginning of a project.
This is probably a little bit more in the weeds than we're prepared to go, but what about the interest that's held in that? Would that be utilized by the commission, or would that also be given? Did you contemplate that?
We have, so again, a lot of this is preliminary. The functions in the statutory language that are proposed allow some flexibility so that this can be built out with experts. And we've done some preliminary consulting with other states and with experts who study this issue, because we are far enough away, but not far enough away that a lot of other jurisdictions are thinking about this problem now. But we have contemplated that the interest would benefit both the state and the developer. Should the developer do what they're supposed to do, they would receive their funds back with interest having accumulated. But some portion of interest is used as a buffer for cost overruns and for other embedded costs in administering this process, because all of it is an estimate. Even if we're doing that estimate and updating it on a regular basis, it still presumes certain levels of risk, certain inputs. Solar decommissioning, should that be the way that solar facilities go, because I do want to acknowledge that might not be the only path for solar sites, is that at the end of 30 years, they all come down. We have renewable energy obligations that presumably will live past the first solar facilities that were built. So maybe they should be reconditioned or repaneled, or they're good sites for further development in renewable space in the future. But if the sites are coming down, they don't pose the same risks as, let's say, obviously a nuclear facility, but also a facility that has toxic chemicals or toxic wastes. Batteries are in this world too. Storage facilities would fall under A5's requirement to ensure decommissioning. They have certain safeguards and protections on batteries, but you could have some cleanup. That's all going to go to ANR if you're talking about chemical contamination and be covered by their program. So we're really talking about infrastructure and site remediation only to restore, mostly soil restoration or removal of small areas that have become impervious surface, like a pad where a transformer has been placed or something like that that was concrete. So it's really removal of those much more stable sort of elements and then return of the condition as much as possible, which tends to be soil replacement and movement of soil on the site to replace things that were stockpiled.
How many sites have been decommissioned in the last 10 years?
0. New England doesn't have much evidence of this at all. The most decommissioning happening in the country is in the Southwest and in California. Their solar program is further along than ours is. The issues in New England are different than they are in the Southwest as well. And like I mentioned, many different jurisdictions are looking at whether decommissioning is the only way of thinking about sort of the end of useful life, because useful life is really an economic concept. It is when a project ceases to be economically sort of cost beneficial to the owner of the CPG. It's at that point that you have to decide whether it's due to panel degradation. When the panels start to degrade, you're not generating as much power, therefore you're not able to, be compensated for the generation of power in whatever arrangement you have. So when you hit that point where the project is no longer financially viable, what are you going to do then? And there are lots of different options in the marketplace, not just taking all the panels down, taking all the racking down, removing the cemented areas, restoring soil horizons, and leaving the site back to the way it was, let's say 30 years or 35 years in the past.
Thank you.
I have a really basic question about the money. And I realize this would be a program that would be designed through rulemaking, but you were talking about return of funds. So just super high level. So I am a developer. I'm building a solar array for a utility to meet its res obligations. I put $200,000 into our new decommissioning fund. And 30 years from now, we decide the site's going to come down. And at that point, my 200,000 is worth 250,000. And the cost of taking it down is less than that. I'm not understanding how the money works.
So we did a back of the envelope for the folks participating when Wes had talked about it on your slide when it says September 11th, Commission issues draft conceptual plan. The idea with that was, and we are not the expert folks,
understood.
but this is what we showed. Let's say the decommissioning obligation in today's dollars is 100,000.
Okay.
It's going to cost 100,000 to decommission this facility. What is that going to be in 2056?
Yeah.
You adjust for inflation, recognizing that's an estimate, right? Because inflation adjustments aren't static. You extrapolate forward, and let's say that 100,000 becomes 140,000 in 2056 terms. Mm-hmm. Then you extrapolate back. How much do you need to invest today based on a rate of return to meet that then? And we're trying to right size those numbers so we don't end up with 2, 3, 4 times that's needed, even if decommissioning had to be done for all of these facilities. Mm-hmm. Because rational folks looking at this problem probably wouldn't say every facility is going to be in this position. I would tend to think it's less than a small chunk of them would ever be in this position. And so how do we make sure this account stays right sized at the beginning, gets adjusted along the way to be right sized when we get there, and you can return these funds to the folks that are following through on their obligation.
That are doing the work. Okay.
And right now it's very hard to estimate what decommissioning, if that's the route we go, will cost, because there's many cost components to that. There are other financial also incentives for folks to do that work that exist that are outside of our regulatory control.
Yeah.
Just apparent, I'm not sure we're getting the same sheets you're giving your testimony on. This doesn't seem to match what you were reading there. And the other question is the Shaftesbury Solar had in there $1 billion decommissioning cost.
20 megawatt.
Well, whatever they approved, they estimated.
Just recently approved together.
It was a very huge amount to decommission and take it down or whatever they got to do. So how much money would they have to put into that fund?
Yeah,
I'm trying to figure out how we're not going to have taxpayers pick up stuff to decommission these things.
Yes, I absolutely agree that I think our goals are to minimize risk to Vermonters and to the state of Vermont in leaving us with an obligation where actually the status quo might not have a dollar available under the construct where we use a financial instrument for the reasons Wes was talking about. So we are looking at something that is more financially stable for Vermont taxpayers, for Vermonters, to ensure these obligations are carried forward. I can't speak on the exact decommissioning obligation in a case because we're not able to talk about those cases, but I think no matter what the amount you're talking about is, we would have an expert come in and tell us how to look at how that estimate is calculated, which by the way, now is done on a private basis. Like each developer is kind of providing us with their decommissioning cost estimates. We would be kind of finding a methodology through this process that establishes the cost estimate through a centralized formula so that is standard and it's done through our expert, methodology. And then that amount is met by what is contributed today based on inflation estimates, and then the state's essentially investment methodology when you have a special fund is to invest that, and it's tagged to the bond rate. So it wouldn't be something like we have to invest in risky stocks or something like that
No,
to achieve
I
it.
understand that. I'm just thinking of one of these operators go bankrupt and do Vermonters have to pick up that tab when the useful life.
That's what they're trying to do. Is to.
Well, yeah, I know, but we've already got many of them already there and none of them have contributed, or they've given you a piece of paper that says the bank may give you a certain amount of dollars, but it's not in hand.
I'm seeing in the PUC filing from Shaftesbury Solar an estimated cost of decommissioning at 1.68 million. I wasn't sure if I thought you said $1 billion.
Well, I thought.
Okay.
He rounded up.
And I'm not saying,
All-
okay, I'm not saying that's nothing. I just want to make sure. Yeah.
So with this fund, with each new facility pay into it to the point where they would, the projected money in the future would cover their decommissioning, or are you trying to create a global fund that would have enough money to decommission whatever the projected 30% of these things that need to be decommissioned? Some of them are going to be in existence for 100 years, right? Theoretically, new panels, whatever so they won't be decommissioned within, a given length of time. So I'm wondering whether you mentioned that. So are we creating a global fund to cover Vermonters on decommissioning a subset of those, or in the hypothetical that all 100% need to be decommissioned in X amount of time? Did I explain my question correctly?
I understand.
Okay. Yeah.
The goal of the fund is that each project has the funding available should it default. The benefit of a fund is that if we got it wrong, like we got an estimate wrong on a particular project, that there are funds to cover that cost overrun. That's sort of the benefit of a fund that an individual instrument wouldn't account for. I wouldn't want to create a scare that we think there's a risk that something like 30% of these are not going to be properly attended to. I think the numbers are far, far lower than that, if any. I mean, some of these projects, like I mentioned, have multiple reasons why the CPG holder will hold on, even if the project is not really financially penciling out anymore. There's other reasons financially that they want to either remove the project or reuse the site or do something else in the future. Also, there is the question of how do we deal with the folks. There's about 90 to 93 current projects that hold decommissioning obligations. Our goal in this process, should we have this authority, is to create a system that has an incentive for those who are already participating in financial instruments to join the fund. That would be the goal. And there's probably a breaking point where we do this correctly, and based on how long those projects have been in existence, there would be an incentive to join, because comparing to the status quo, every 3 years you have to secure a bank letter of credit, and that you're paying a 1 to 5% fee on obtaining that letter of credit, and you're doing that every 3 years for 30 years. I mean, it's 10 times minimum. You're securing that instrument at 3% of your total decommissioning cost, adjusted for inflation each time, plus the lawyers fee to file, or your management costs. So if you pencil that out, you can imagine that those numbers, and we've looked at them somewhat, we've compared these, that if we get the number right, you're eliminating this uncertainty, you're eliminating this constant need to interact with the regulator on this one obligation. that upfront investment is certain. It helps with financing a project. It helps with knowing what the full financial obligation investment cost is going to be, including decommissioning. And right now they don't have that.
93 sites have decommissioning obligations. How many do not have decommissioning obligations?
There's a break point for when the obligation kicks in, which is if you're at or under 500 kW, you have the obligation to remove the facility at the end of its useful life, but you do not have a financial instrument obligation.
Below 500, no financial, above 500, financial. And do these obligations quantities vary on properties that have a lease agreement on leased land rather than owned in fee?
The obligation from the commission standpoint is the same. It doesn't matter what your ownership or leasehold relationship with the landowner is. Our understanding is that localities and landowners do rely on the fact that folks are paying or holding some sort of decommissioning fund in order to obtain those agreements. If they are leasing, they want these types of assurances as well, that the facility will be removed.
And to the extent that decommissioning, you mentioned concrete, so removal of and restoring soil, but obviously you can't restore trees. You can replant food, can regrow or freezing that down. Right, yeah, maybe.
Some facilities do have aesthetic mitigation planting plans that were required at the time the CPG was obtained, so they may have been already required to put in at times hundreds of trees for purposes of aesthetic screening and other functions. There are certainly sites where trees are cleared, and there are sites where some have been planted, and 30 years in the future, hopefully some of the ones that are planted would have grown to maturity. But yes, they can't replace the ones they took down directly.
Just quick question about cost overruns. It would seem, just playing out your scenario about, suppose the decommissioning cost of a site exceeded what the estimate was, and all of the financial factors that are hard to predict come into play, that you still have to collect enough from each CPG holder, each CPG developer, enough to actually exceed the projected cost, so that you weren't in a situation where you had cost overruns, because you're returning the full amount of the fund to the holders who do decommission their projects properly, right? So, I mean, just conceptually, theoretically, if everybody who does the decommissioning properly gets the full amount of their contribution to the fund back, and you only have one project that you have to pay for the decommissioning after that, and that project costs more to decommission than anticipated, and you're still left over the bank. So it's or the state is still left over the bank. The taxpayers aren't. So you'd have to. Am I saying this? Does this make sense to you? You'd have to collect enough to account for potential cost overruns. In other words, a contingency fund or something like that. Isn't that so? Or am I missing something here?
Not missing anything. I think our hope is that the way we're looking at this problem would allow for the collection of funds that grow over time, such that the interest is shared somewhat. So the growth on these funds over time would be returned mostly to the person, CPG holder entity that is doing the decommissioning correctly, but that some small portion was retained for the purposes of cost overruns and administering the program. And that's the map that we want a consultant for.
I see. Okay.
It's a complicated formula methodology that's used to make sure that all of the goals of this system are accounted for financially.
You've explained it now, so I maybe you did that hit that before and I missed it. But anyway,
No.
Good. Thank you.
Rep. Torrey, sorry. Rep. Clapton, then Rep. Torrey. Go in the wrong order.
Is there data out there about how good or bad we are in general at estimating decommissioning costs in terms of money we collected and then 30 years later found out whether it was enough or not?
Us specifically.
I mean,
Vermont,
nationally for energy projects.
So one of the organizations we consulted with is NREL. They're the ones doing the most national work on collecting data on decommissioning. They just recently completed a 50-state analysis, both in terms of what decommissioning estimates look like, and also what mechanisms they have in place for ensuring it financially. In New England, we don't know yet because we don't know. We're not at the place where we can know what happened at 30 years and look back and say these were the factors that influenced up or down. But the folks that are studying what influences play into how much a decommissioning estimate should be in today's dollars versus what might happen in 30 years are looking and constantly tweaking those formulas. The way we collect decommissioning estimates now is, like I said, dispersed to all the different developers who make their filings with us, some of whom do it internally, some of whom use engineers and consultants. Creating uniformity there is one good place to start, where at least all the inputs are the same and we're looking at all the inputs in the same way, as opposed to you will see within New England the same size 2 megawatt, 5 megawatt project having a decommissioning cost estimate in Connecticut that is different than Maine by 2-3 times. And why that's happening, or we're just not there yet. We don't know all of the information, but knowing it and pointing it out and looking at it and thinking about it, I think is the purpose of this, is just to create uniformity, have those numbers be stable, clear, all the inputs laid out, and so we can then judge against that what's necessary for the current future, if that makes sense, rather than the 10 years from now future, or the 25 years from now future.
It seems as though in Vermont, we've recently decommissioned a decent number of dams. Like we're decommissioning 1 a year, 2 a year, whatever it is. So presumably we know how much that costs. And so this applies to hydro as well. So got hydro data, but not solar data, because we haven't decommissioned many solar farms.
Yes.
Got it. Thank you.
I was curious about other states. Is the fund approach popular, or are there other states that have gotten a little further along?
There are no other states that have a decommissioning fund,
No other.
but in doing research into the topic, we have several states that are in our inboxes wanting updates on how ours is
Let's
going.
go.
So it's something other states are interested in. And I think it's fair to say that a number of other states are looking for creative solutions to this. I wouldn't call it a problem, but this situation.
Yeah, I could see like agencies of natural resources leading on it instead of PUCs.
Right. A lot of other states handle siting very differently.
Yeah.
So I think in our research, we saw that in New Hampshire, their PUC may not get involved unless a solar array is above 40 megawatts. And it would be handled at a sort of a local zoning or permitting level. I don't mean to overspeak on topics I'm not aware of, but that sort of concept is common in other states. So we're a bit unique in the sense that we being the PUC oversee siting of relatively smaller solar facilities, and we have obligations to ensure that they're decommissioned.
The only state that provides CPGs to solar facilities of these sizes. And when you look at other jurisdictions, much of the decommissioning financial assurance piece, as Wes was alluding to, is handled either privately or at a locality. So municipalities have requirements. Sometimes they're state forced requirements. Sometimes they're municipal generated requirements, or they push it completely to the private contract negotiation. So if you're getting a leasehold from a landholder, that lease would hold a decommissioning requirement and obligation and some sort of financial assurance for the landowner, but it's not managed or regulated by the state or the municipality. So
apologies if you explained this already. Would the funds also be available to the developer to recondition the site? And that seems a much more likely scenario to me, that they would put on new panel, put on the new generation of panels. Or
so our goal would be that this system, this model or the fund model would take into account different end of financial useful life
Okay,
scenarios, and it
Okay.
wouldn't just be geared toward taking the racking
you did say
panels
that.
down.
Yeah,
So
you said that.
we hope to gather as much information about what those possibilities look like and whether perhaps an investment today in the fund won't be required in the same way in 20 years.
Mhm.
Because what's happening on sites, we have that data now and we can tell the legislature and others what's happening. We will know what's happening and we can tailor this approach to better suit what's actually needed on the site.
Yes. Seems to me that, the more we can eliminate externalities in our economy, the better the economy works, the more accurately it works. And we have a lot of sad experience recently and over the last 100 years of companies going bankrupt and leaving a mess, which is a fine example of an externality. They've dumped all that cost onto the neighborhood, typically a physical geography, whether it's a mining company or the barge canal in Burlington or other infrastructure that's left stranded. So conceptually, this feels very consistent with the notion of economic actors having responsibility for the costs of their actions over the lifetime of the effects of those actions.
I will say that we look to several of ANR. ANR does have several cleanup funds, and we based the language we proposed off of those models. And so I think that's just sort of to your point about how to regulate risks like that.
Which sadly means our generation has to pay for the last 100 years plus the next 30 years. I mean, functionally, that's where we're at because we didn't do this 100 years ago, which would have solved us a lot of problems. But that's where we're at. That's what we have to do. So let's do it. Good thing we're young and strong.
Other questions, comments? So, we have Rep. Campbell put in a bill to move forward the plant language as defined, and you said you have suggested legislative language for the decommissioning.
Yes, the letter that was submitted to the committee with the plant report,
Has that?
the last
2 pages.
2 pages are the proposed statutory changes and or new language.
It's really hard to find in this.
And apologies, we did not resubmit the report and the letter with our slides and the comments.
That's okay.
did
We
submit.
have it and or can get it, and we'll make sure it's posted with your best meeting.
Great, thank you.
Yeah.
Thank you.
Okay. Thank you very much for your work.
Thank
Appreciate you coming in. We are adjourned for the week and we can go off live.